with District South Real Estate Company here, and I am joined with a wonderful guest, Louis LaBruyere of Bayou Title. Thank you for coming.
Thank you for the invite. I appreciate it much.
So today we're going to talk about successions and real estate, but first let's learn a little bit more about you. Tell us who you are, a little bit about you, and how long have you been in the industry?
Sure. So Louis LaBruyere with Bayou Title. I've been doing this for 24 years now. When I first got out, I did a little bit of everything, but really gravitated to the real estate world and the title world very early on. So yes, I've been doing this for 24 years. Don't hold that against me. I look a lot better than that. But thoroughly enjoy real estate. That there's nothing else I'd want to do. It's a great industry, and from there, it's still going strong, and plan on keep doing it for a long time.
Yes. So a little bit about me. Obviously, I am a real estate agent now, but I have 12 years as a real estate paralegal, and Louis is the only attorney that I worked for in Lafayette. So I was with him for about 4 or 5 years, I believe.
So your base is from me. Everything you learned early on was from me.
Yes.
So
we'll go with that.
Okay.
Yes. Okay, so let's talk to people who they've heard the word succession, they've heard the word probate. What really is the difference? Is there a difference?
Practically speaking, as far as everyday terminology, there's no difference, right? People use succession, probate interchangeably, so there's real no difference. Technically, yes. When we say probate, we're talking about somebody has a will, so we want to probate the will, which means the judge is going to look at it and make sure it's in the correct form and that everything is in good shape legally. So when we say probate, we're talking about a will. But really and truly, people use those terms this way and that way. Succession and probate, same thing. We have a deceased person. We now got to get the assets into the heirs.
Okay, great segue into the next question. So let's say
I read your questions.
Surviving spouse that comes to me and says, hey, I'm ready to sell my house.
Okay.
Now what? What's the first thing they need to do?
Well, first thing, and you alluded to this before and other things, is, where do you start? Who's supposed to sign? The first step is, right, get the listing, right? And you do want to get that going because you want to be marketing while we're doing our stuff, especially if we know ahead of time. So as far as who's to sign a listing agreement and that, so the surviving spouse can definitely sign a listing agreement. Now, if there's other heirs, such as if the eventual heirs are going to be the children, they also need to sign that listing agreement. Now, even though the succession is not done, that's okay. Have them sign a listing agreement, have all the owners, have all the vested owners and these heirs sign the listing agreement, and then we go from there. Right. In the meantime, we do want to get the succession done, okay? Right. So Louisiana does recognize who the heirs are going to be, and they do have ownership rights at the point of the deceased dying. So with that, all we're doing at that point is we're going to see a judge and make it legal, right? So we want to legally pass on the assets to the heirs. So we want to open up the succession, okay, and get that started, all right?
Right.
Then from there, man, we can go in a lot of different directions on this, on how to do it. Opening up the succession is easy if everybody is close by. If everybody is in agreement, I'm talking without a will right now, without a will, just general intestate. If everybody's in agreement, it is so easy. Right. It can be done very easily, very quickly. I have done them in one day, especially if we didn't find out. It happens. You don't find out till a week before closing. Oh yeah, by the way, so-and-so died. Okay, thanks. It does happen. It doesn't seem like that would happen, but it does happen enough. Right. Yes, if everybody's in agreement, we can get it done in a day.
Right.
Okay. We'd like a week, but we can do it in a day.
Yeah. So as a listing agent, my process, let's say I get this client, I realize former spouse has passed away. At that point, sure, we can sign documents, but legally, that surviving spouse can only sell the percentage that they own.
Correct.
If I do not have the children sign, and it goes even deeper, let's say they're adult children and one has passed away and now there's grandchildren, it's a big tangled spider web, right?
Yes, absolutely.
And so having an experienced succession attorney involved in the transaction lets that go as smoothly as it possibly can, as well as educating everyone and protecting me. Because if I just start marketing a house with just surviving spouse, no children have signed, now I have put myself up for liabilities because I can't sell a half a house or a portion of a house.
Cannot.
So you talked about intestate versus testate. So
Correct.
having a last will and testament versus not.
Okay.
Let's have this conversation.
Good.
Pros and cons.
So let's start off with if you don't have a will, okay? If you don't have a will, you have to make sure you're okay with what Louisiana intestate law says, which basically, now great, there's exceptions for every rule, right? So the basic rule says if it's community property, the surviving spouse is recognized as a one-half owner, and then the kids would be recognized as the other half owner, okay? So that means in a normal situation, Louisiana law does work, right? Because in general, we want the surviving spouse to have 50% ownership, recognized as 50% owner, and by law, that spouse also has a usufruct over the other 50%, which means she can use it and do what she needs, and the kids would be the naked owners, the owners of the other 50%. So if you're good with that, really no need for a will.
So let's break this down, because I really want people to understand. Husband and wife buy a house.
Okay.
I own 50, husband owns 50.
Okay.
He passes away.
Mm-hmm.
What of his 50% do I get, if any?
0.
Right.
So the spouse.
Everything we've built together, I still own only my 50. His goes
Correct.
100% to the children. His share, his
Yes.
50% share, goes 100. So I have this conversation with my clients who buy houses with me, right?
Okay.
They buy a house, great, happy, happy, joy, joy.
Okay.
But because I have the paralegal background, I always say, now you have the house, here's the keys, make sure you do a last will and testament to protect your spouse. If you don't, you truly are subject to whatever the laws are at the time of death of the spouse.
Correct.
And so without the last will and testament, you're leaving yourself open. I have people that sometimes the husband might have a last will and testament to protect the wife, but the wife doesn't do the same to the husband, and it's like, hey, this is getting messy for the future. So it's just a good conversation to have.
I agree.
What do we want to do to protect our significant other? Because technically, with the last will and testament, it doesn't have to be your spouse. It can be anyone. You distribute your assets
however you
choose.
And that's the thing, I was thinking about that. You remember a will is in essence a blank contract, right? And you have all the authority, and your will will actually be put into place. So whatever you want will be done. You can do anything that you want.
Yes.
You don't have to necessarily follow the normal laws of the Louisiana.
Right. And there are parameters that people can have deeper conversations with forced heirship, things like that. But that's a whole nother topic. But let's dive into
before we get that, just something basic forced heirship, because a lot of people don't understand. It's just a definition. So a forced heir is any descendant, we just talked about the kids, first degree, descendants of first degree, kids that are 23 years old and younger. You cannot write them out the will. They are going to be forced heirs and they will inherit something, okay? And if you have a descendant, a kid, that either has a physical or a mental incapable of taking care of themselves from a physical or mental standpoint, they are also forced heirs. And at that point, they will always be a part of your inheritance.
Right. Yeah. Okay, that's good information for people to have. Sometimes people are scared to call an attorney. They think everything you do is astronomically expensive. I know it can, depending on how deep. But let's talk a very simple will. I leave everything to my spouse. He leaves everything to me, vice versa, and or a very simple succession.
Okay, good.
Can you talk cost on that?
Sure. So as far as a will goes, especially if you keep it simple, we call them I love you wills, where he gives everything to her, she gives everything to him. I love you wills. That we would charge $350. Our normal range is $500 to, I'm gonna say $500 to $1,500, depending on how complicated. Some people want to put trust in there and all that, so it get complicated pretty quickly. So $500 to $1,500 is your basic range, but if it's a simple I love you will, $350.
Okay, I think that's good to know, because I think again, you've just bought whatever the house is, a $300,000 house, a $600,000 house, whatever that is. If you're not protecting your spouse, but that you intend to, that's what you desire, another $350 at least protects that one asset.
Yep, and we can do that. You can do it by per asset, right? You don't have to say everything to the spouse. You say, hey, house is going to spouse, period.
Right, yes. Is there anything else you feel like people should know about last will and testaments or successions?
Okay, so as far as that, let's just talk about just quickly. I'll try to do it quickly. The different types of succession. So what's important is, yes, if everybody is in agreement, simple, easy, go in front of the judge. We get a judgment of possession, which is the final document we need where the court is recognizing who the actual heirs are. Once we have that, we're good. The heirs now own it. They're good to do everything. Okay, that's a simple succession. There are other ways to get this thing done quickly. We can do it where we actually put the succession under administration and we do an independent administration, okay? That can be dictated by the will, if we have a will, or if not, if everybody agrees to put one person in charge to sign everything. That's very, very good for what we do, because then we don't have to worry about getting multiple signatures once, and then after that, we're just dealing with one person. So that's what we're looking for, putting one person as independent administrator or administratrix, and then that one person can handle everything. One more thing, we do have what's called a small successions and what's called a small succession affidavit. If the assets are $125,000 or less, we can do it by affidavit. Do not need to go see the courts, do not go see the judge, get it done very, very quickly. Again, as long as we got full help and assistance from getting the right signatures we need, all the heirs have to sign. Once we do that, that can be done immediately, and don't see a judge, get it recorded. It's very quick, under $125,000.
Love it. So a lot of great information here for people who have confusions about succession and real estate and or pros and cons of last will and testament. And so tell people where they can find you.
Oh, good. So I am involved or manage 4 different offices, 4 Bayou Title. I'm normally in the River Ranch office in Lafayette. We have offices in New Iberia, Opelousas, and Lake Charles. Feel free to use any of that. Bayou Title in general, we do have 20 offices statewide. So that's also very important. If you have buyers that have already moved or sellers that are in town, no problem. We will have an office close enough to provide the notary work for free and provide a conference room to get everything signed.
Thank you so much for joining me. I hope this has been some really educational information for anyone watching. And again, Melissa Gaubert and Louis LaBruyere, and have a great day.
Thank you.